The CEO's daughter fired me over Zoom at 9 a.m. I owned the patent that made their $740 million client untouchable without my signature. She had been with the company 8 months. I had been there 14 years. The Zoom call lasted 6 minutes and she read from a script someone had written for her. I could tell because she mispronounced the name of the department she was eliminating. She told me the company was moving in a new direction and that IT would disable my credentials by noon. I thanked her. I closed the laptop. I sat at my kitchen table for 4 minutes looking at the coffee I had not finished. Then I opened a different laptop, a personal one, and pulled up the patent filing I had completed 18 months earlier on my own time using my own equipment before my employment contract had been amended to include an IP ownership clause. The filing predated the clause by 63 days. My IP attorney confirmed it on a call that same afternoon. The patent was mine. Fully, legally, completely mine. Their largest client, a firm generating $218 million in annual revenue, had an entire product line built on that patent. By the end of the week, I had sent one letter. By the end of the following week, their client had sent a different one. The CEO's daughter called me personally on a Thursday evening 11 days after the Zoom call. Her tone was unrecognizable from the woman who had read me that script. I let her finish before I told her to contact my attorney. Part of me wondered if I was being too deliberate about all of it. I decided I was not. I'm 41, male, senior systems architect. I have one of those faces that people forget at parties but remember when they need something fixed. I had spent 14 years at a mid-sized tech firm in Austin, the kind of place where everyone knows the coffee machine is broken on Thursdays and nobody reports it because fixing it feels like someone else's job. I was not flashy. I was not political. I showed up, I built things that worked, and I went home. That was apparently the wrong strategy. The Zoom call was at 9 a.m. on a Tuesday. I remember that because I had a full cup of coffee in front of me and I never got to finish it. The CEO's daughter, she had been with the company 8 months, brought in under the title of Chief Transformation Officer, a title the company created specifically for her, opened the call by looking slightly to the left of the camera. She had notes. Written notes on actual paper, which she was clearly reading from because she mispronounced infrastructure optimization as infrastructural optimization, and then moved on without noticing. She said the company was moving in a new direction. She said there were going to be structural changes. She said IT would disable my credentials by noon. The whole call lasted 6 minutes. I said, "Thank you for letting me know." I meant it to sound professional. I think it did. I closed the laptop. I sat at the kitchen table. Then I opened my personal laptop, a beat-up ThinkPad I use for side work, and I pulled up a folder I had not opened in months. Here is the thing about patents. Most people in tech don't think about them until someone else does. I had been thinking about them for a while. 18 months before that Zoom call, I had developed a data routing architecture on my own time, over 3 weekends, on my own equipment at home. It was a method for handling multi-tenant API authentication at scale in a way that reduced latency by about 40% without requiring additional server allocation. I filed for a provisional patent. I did this before the company amended my employment contract to include a clause assigning all IP developed during employment to the company. The amendment came 63 days after my provisional filing. I know this because I had an IP attorney review both documents the same afternoon I was fired. She confirmed it inside 2 hours. The patent was mine. Fully. Legally. Completely mine. I sat with that information for a few minutes. Then I made a list. The company's largest client, a financial software firm, had a product line built on exactly the architecture I had patented. Not something adjacent to it. Not something inspired by it. The actual method, implemented almost identically. I knew this because I had been the one who integrated it. I had the documentation. I had version history. I had emails where I explained the implementation to the client's engineering team. The revenue that client generated for my former employer, approximately $218 million annually. Their whole product suite was wrapped around my patent like insulation around a pipe. I called my attorney again that evening. We talked for an hour. She said the position was strong. She said we should send a letter. We sent one the following week, a formal notice of patent infringement, not to my former employer, but directly to the client. I want to be clear about what happened next, because I think the order of events matters. The client received the letter on a Wednesday. By Thursday, they had forwarded it to my former employer's legal team. By Friday morning, their general counsel had called my attorney. By the following Wednesday, the client had sent their own letter to my former employer, notifying them that all payments were being suspended pending resolution of the IP dispute and that they were reviewing their contractual obligations under the indemnification clause. That clause required my former employer to defend and indemnify the client against exactly this kind of third-party IP claim. Meaning, the $218 million relationship was not just paused. My former employer was now legally on the hook to cover whatever it cost the client to fight or settle my claim. The risk on their books went from zero to significant inside 10 days. During this period, I heard nothing directly. My former employer's legal team was communicating with my attorney. The tone of those communications, from what she described, shifted noticeably between the first call and the third. On day 11, my phone rang. Unknown number. Texas area code. I picked up. It was the CEO's daughter. She did not open with an apology. She opened with a question about whether there was a path forward. She said the company valued my contributions. She said the termination had been a difficult decision made under complex circumstances. She said she hoped we could find a way to resolve the situation that worked for everyone. I noticed that she did not say the termination had been wrong. She did not say they had made a mistake. She said complex circumstances, which is the corporate phrase for we don't want to admit fault but we need something from you. I let her finish. Then I said, please contact my attorney. I hung up. Here is where the entitlement started to show its full shape. Within 48 hours of that call, they made 3 separate moves that I only learned about later through my attorney and, eventually, through discovery. First, they contacted 3 of my former colleagues, people I had worked with for years, and asked them to provide written statements asserting that the architecture in question had been developed collaboratively on company time. 2 of those colleagues refused. 1 complied. I have no anger toward the one who complied. I understand pressure. Second, they hired a law firm to file a motion challenging the provisional patent on the basis that the filing date should be considered fraudulent because I had used company resources in the development. The company resource they cited was my work email address, which appeared in one exchange with the patent attorney's office. A single email address. That was the foundation of their challenge. Third, and this is the one that still makes me take a breath, the CEO himself called my IP attorney directly and told her that things could get messy for her professionally if she continued to represent me aggressively. My attorney documented the call, sent a certified letter to the company notifying them that this constituted potential witness tampering and interference with legal counsel, and then forwarded the documentation to the Texas State Bar with a formal complaint. After that, the company's outside counsel sent a letter to their own client telling them to stop making direct contact. The patent challenge failed. An email address used for professional correspondence does not constitute use of company resources under USPTO standards, and the examiner dismissed the challenge in a written decision that was, I'm told, unusually direct in its language. The colleague who had provided the written statement later retracted it. He sent a corrected affidavit to my attorney explaining that he had been told the statement was just a formality, and that he had not understood how it would be used. I believed him. I still do. The bar complaint against the CEO is still open, as of the last update I received. The settlement negotiations took 4 months. I had a very clear attorney and a very clean factual record, and on the other side there was a $218 million client relationship that had been frozen and a legal team that was increasingly aware of how their client had behaved during the dispute. I was not trying to destroy the company. I want to say that clearly. What I wanted was acknowledgement of ownership, a licensing agreement with terms that reflected the actual value of the patent, and back compensation for the period during which the technology had been used without my knowledge or consent. What I got was close to that. The licensing agreement is structured over 7 years. The terms are confidential. I will say only that the number is meaningful, and that I no longer think about the cost of my daughter's college tuition with any anxiety. As part of the agreement, the company also issued a written acknowledgement that the patent belongs to me and that its previous challenge to the filing was made in error. They did not offer an apology. I think about the 6-minute Zoom call sometimes. I think about the way she looked slightly to the left of the camera. I think about the fact that IT disabled my badge access before the call even ended. I know this because a colleague texted me at 8:58 a.m. saying he'd tried to forward me something and my email had already bounced. I do not think about it with rage. That surprised me. I thought I would be angrier. Instead, I mostly think about the 4 minutes I sat at the kitchen table looking at my cold coffee before I opened the other laptop. 4 minutes is a short time to cross from one version of your life into another. I try not to waste many of them. If you stuck around for all of that, honestly, you deserve a patent on your own patience. Hit subscribe so you don't miss the next one, because apparently I'm just getting started.